72 hours. That's all the time the Department of Justice has been handed to replace an entire squad of elite federal lawyers before some of the biggest corporate and civil cases in the country start falling apart. This isn't one attorney getting reprimanded or quietly pushed aside. A federal judge just reached for the legal equivalent of a kill switch, wiping out Attorney General Pam Bondi's entire hand-picked litigation team from 23 active matters. Everything is frozen. More than $127 million in litigation, major antitrust fights, and enormous defense contractor fraud cases have slammed into a wall. And when you actually sit down and read the 47-page order that detonated all of this, like I have over the last 24 hours, you realize the cable news version barely touches the real bombshell. Let me pull you behind the curtain, because the details buried as early as page 8 are enough to stop you cold. There are no extensions waiting in the wings. No routine appeal process that buys the department a few extra weeks. The judge ordered immediate compliance by Thursday, March 26th. And if you're wondering how the DOJ ended up scrambling to rebuild 23 federal cases, basically overnight, you have to follow the timeline. Pam Bondi took over the Justice Department after a bruising confirmation fight, and she brought in a specialized litigation team built for the toughest cases on the board. But weeks ago, defense lawyers in 3 major matters started sounding an alarm. They argued that this new DOJ team came in carrying deep, pre-existing client relationships that crossed a dangerous legal boundary. We hear all the time about Washington's revolving door. Lawyers move from defending corporations to prosecuting them, and then right back again. But this judge, a Reagan appointee no less, spent 11 pages explaining why this wasn't just business as usual inside the Beltway. He called it a structural, irreconcilable conflict of interest. Not something that merely looked suspicious. He said actual, concrete conflicts had been established. So what did Bondi's side say after this legal earthquake hit? Just 2 sentences. They called the ruling procedurally irregular. That was the whole response. And that's not a factual rebuttal. That sounds like a team trying to buy a little oxygen while the building is already burning. Because once you start reading the filings submitted Monday, a much darker picture begins to emerge. On page 12, lines 4 through 9, the court says the government's lead counsel still held an active partnership stake in the law firm Morrison Foer while directing litigation strategy against former clients of that same firm. Let that settle in. The federal lawyer steering these prosecutions had financial ties to the firm tied to the other side. And it goes further. On page 31, the judge lays out 7 separate moments when federal strategy discussions took place within 48 hours of major payments going to that connected firm. We're talking about wire transfers adding up to more than $3.2 million over 19 months. You do not need a law degree to see why that raised alarms. Now look at how this team came together, because the timeline tells its own story. In November of 2025, the first conflicted attorney joins the DOJ roster. By January 2026, a second lawyer from the same firm network is brought in. Then in March 2026, a third arrives, and not just another attorney, but the former managing partner of that same firm. But here's the part almost nobody in the mainstream press is talking about yet. It's buried in page 38, footnote 14. The judge says Attorney General Bondi personally approved these hires even after receiving formal written warnings from the Office of Professional Responsibility, advising her not to move forward. Think about that for a second. She was warned in writing more than once and approved the hires anyway. Those memos are attached as Exhibit G, and the tone gets more urgent each time. The first memo in September uses the usual careful bureaucratic language, recommending against the appointments. By November, the warning sharpens, saying continued use of these attorneys could trigger judicial intervention. In January, a formal objection is filed. By February, the Career Ethics Office says it has exhausted all internal remedies. For separate times, internal watchdogs were effectively yelling stop. And because no one listened, the judge used those same memos as the final blow, saying the government cannot pretend to be blindsided when its own compliance system raised the alarm again and again. So where does this leave everything now? The consequences are massive. The tech antitrust case with $89 million on the line? Paused. The giant defense contractor fraud prosecution involving 41 defendants? Frozen. A major civil rights enforcement action? Stalled. Every one of them is now waiting for Trump's DOJ to somehow produce an entirely new team of highly cleared, highly specialized attorneys within 72 hours. And they can't just plug in anyone available. The replacements must have zero ties to the firms the judge identified, no past representation of any party in the cases, and they have to submit complete financial disclosures directly to the court. On page 44, the judge makes it unmistakably clear that every replacement will be examined under a microscope. And then, on page 47, he delivers one final warning that should terrify the lawyers already thrown off these cases. He reserves the right to refer the whole matter for formal bar discipline. In other words, this isn't just about losing cases. Some of these attorneys could be staring at the loss of their law licenses altogether. But to be fair, if we're going to look at this honestly, the DOJ's defenders do raise arguments that can't just be brushed aside. There is a real case to be made that this ruling goes too far. The technical ethics rules and waiting periods may very well have been followed to the letter. These lawyers had formally left their firms. And the history matters here too. This same judge has already ruled against this administration's DOJ on procedural grounds twice before. So is there a pattern from the bench? Possibly. Even a Georgetown legal ethics professor, someone not exactly friendly to this administration, said on the record that the conflict standard being used here is far tougher than what federal courts usually apply. The kind of revolving door conduct that happens under every president is, all of a sudden, being punished with a hammer. And the timing raises eyebrows. Defense lawyers waited until the point of maximum disruption to file these motions. These cases were inside 60 days of trial. Was that strategic? Absolutely. The judge even acknowledges that on page 22, but says a strategic filing doesn't make the underlying conflict any less real. And maybe the strangest part of all is what didn't happen. There was no stay. Normally, when a ruling this sweeping comes down, the judge hits pause long enough for the government to appeal. Not here. This order took effect immediately. The DOJ is now racing to the appeals court, practically pleading for emergency relief and arguing that the conditions are impossible. And this is where the ticking clock gets loud. If the appeals court grants a stay by Wednesday, the entire thing goes on ice and Bondi's team lives to fight another day. But if the appellate judges stay silent, then Thursday becomes one of the most consequential courtroom moments of this administration. A supplemental remedies hearing is on deck, and the judge could impose huge financial sanctions, or even dismiss these cases outright. And here's why this matters beyond the spectacle and the politics. If you have a 401k, if you own stocks, if your retirement is tied to the market in any way, this reaches into your world fast. The tech company at the center of that antitrust case carries a market cap of $340 billion, and its stock moved 3% the moment this order hit. Institutional investors are now waiting to see whether these federal cases survive Thursday morning. But there's an even bigger issue here. This could reshape the legal standard for conflicts of interest in federal court. The line may have just moved hard. The flexibility that has defined Washington's legal culture for decades may have vanished in a single order. Now the countdown is on, and the silence from the appeals court is becoming its own kind of thunder. The DOJ must file its response to the sanctions motion by Wednesday night. At the same time, it is frantically vetting replacement lawyers ahead of a Thursday morning hearing. The judge has built an almost fortress-like record, 340 pages of exhibits, suggesting he crafted this ruling to withstand an appeal. What we're watching now is a brutal game of legal chess happening in real time, and Thursday morning will decide whether this DOJ team is dismantled for good or somehow pulls off a last-second escape. I'll be following the docket minute by minute, and the second the appeals court makes a move, or the moment that gavel comes down Thursday, I'll be back here to break down exactly what happened and what it means. So make sure you're subscribed and notifications are on, because this story is moving fast, and the headlines you're seeing right now are only skimming the surface.